You might have it muted. Can you all hear me at the main jail? Can you hear me at the main jail? Just stick your hand up or something. Okay. All right. Good morning, everybody. My name is Judge Robert F. Diaz. You're here for your magistrate hearing today. What I want to let you know is for the purposes of this magistrate hearing, I'm going to appoint a public defender to represent you. That only means that the public defender represents you at this hearing. That doesn't mean they represent you from here on out. That would happen at a separate time and place where you would be able to get a public defender to represent you. We have a public defender in the courtroom and one with you there in the jail. What I'm going to do is I've come in, I've read all the police reports. I need to make a legal determination to find out whether the state has probable cause to hold you. I will state your name. I will tell you what the charge is. I'll tell you whether I find probable cause. If you're here on a misdemeanor, there may be a chance to resolve your case. Some misdemeanors, I cannot do that, but I would tell you ahead of time what the plea would be if you wanted to resolve your case. Once we get to the felonies, I'll make an announcement. After that, there are no pleas being offered. We can't resolve cases, felonies here at magistrate. So I have two cases to call. If you'll tell me the names of the people you're here for, sir.
Mr. McLawrence, it's Gerard Ferris. Both are on page 8. Gerard Ferris.
Let me go one at a time. When I find the first one, I'll find. Because I don't have pages. I just have lots of things.
Paperwork.
Gerard Ferris I have. What's the other one?
Yes.
Hold on.
Yes, sir.
You okay?
And Donald Davis, I think, should be right behind him.
Next behind it. All right, where's Mr. Ferris?
Both.
Ferris is at Con.
Okay.
Ferris is on his way, but I have Mr. Davis.
All right. Mr. Davis?
Yes, sir.
Good morning, sir.
Good morning, sir.
You're here, it looks like you're charged with, there's a warrant out for you. It's a count 2, so I don't know what your count 1 is. I don't know if you have another case, but this is for a petty theft.
Yes, sir.
And this is for a municipal ordinance violation. I find probable cause. Your bond is $500. You can either get yourself a private lawyer, you can represent yourself, or we have an assistant public defender here for the city of Fort Lauderdale here if you'd like to see if you qualify for that. What do you think you want to do?
I don't have a public defender.
All right. I'll go ahead and appoint Can you give me a second? I'll go ahead and appoint Mr. Odom to represent you. All right, he'll be out to see you, sir.
Thank you, Judge.
Your Honor, he's on his way. I can notify you as soon as he gets here. It should be 5 minutes. I'm so sorry.
No. I'm only smiling because in the new courthouse, everybody's saying they'll be here shortly. I found out lately it's the elevators that's holding everybody up, so I don't know what's going on over there.
Yeah.
All right, will you let me know?
Yes, sir.
All right. I'll keep that separate, sir. Stephanie Bernice Miley.
She's in North Broward, Your Honor.
Good morning, Miss Miley.
Good morning, sir.
You're charged with, there's a misdemeanor warrant out for you. I find probable cause. Your bond is $500 on the warrant.
She would like to resolve it as possible, Judge.
If you want to resolve your case, it will be an adjudication, 3 days in the Broward County Jail. I'd have to charge you $50 cost of prosecution. I don't have any choice on that, but I'd give you 180 days to pay that. Are you interested in that, or do you want to get a lawyer? What would you like?
I'll take 3 days, sir.
All right, you understand all the rights you're giving up?
Yes, sir.
What do you plead, miss? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea. I'm Ms. Miley, 17902 MM40. I'll adjudicate you guilty. Time served, $50 cost of prosecution, 180 days to pay. Good luck to you.
Excuse me, Your Honor.
Yes.
Copy has Mr. Ferris.
Okay, Mr. Ferris is here.
Good morning, Judge. George, on behalf of Mr. McLawrence.
Hi, Mr. Ferris. Sir, you're here on a count 2. I don't know what your count 1 is, but this is a petty theft warrant. It's a city ordinance case. The warrant is, I find probable cause on the warrant, it's $100. You can represent yourself. You can get a private lawyer, or the assistant public defender for the city of Fort Lauderdale is here. What would you like to do?
I'd like to resolve the case today, sir.
Okay. If you want to enter a plea, I would adjudicate you guilty, 3 days, $50 cost of prosecution, no return to that place. Are you interested in that?
Yes, sir.
All right. You understand all the rights you're giving up?
Yes, sir.
What would you plead? Guilty, not guilty, or no contest?
No contest, sir.
I'll accept your plea on Mr. Ferris, 17701 MO10. I'll adjudicate you guilty. 3 days, credit for any time served, $50 cost of prosecution, 180 days to pay. All right, sir?
Yes, sir, I'd like to say something to you.
Of course.
Yes, I'm a boat captain by trade, but I was just diagnosed with diabetes, and I've had a problem here with finding a place to live. So
Okay.
The reason why I had this problem is because I was homeless.
Okay.
So I just wanted you to know that.
I appreciate that, sir.
I do have time in the community. I'm born and raised here in Broward County, right down the street at Broward Hospital.
Okay.
So I do have ties to the community. I'm trying to find work. However, it's been difficult since I don't have home right now. So
Okay.
that's the reason. That's
All
the
right.
reason why I had this problem.
All right. Good luck to you, sir.
Yes, sir.
All right.
Thank you very much.
You're welcome. Kaylee Nicole Fontana.
North Broward.
Hi, Miss Fontana.
Hi.
You charged in count 1 with possession of cannabis less than 20 grams. I find probable cause. Your bond is $100, miss. You can bond out for that amount.
Judge, she can't. She's here from Las Vegas. She has no friends here. She has no family here. According to what she tells me, there is absolutely nobody out there who can help her post this $100 bond.
Okay.
I know that ordinarily the court does not make offers on marijuana or cannabis charges, but I think this is somewhat of a unique circumstance in light of the fact that she's probably not going to be able to make that $100 bond. She'll sit in jail for a long time until the Broward Sheriff's Lab gets around to testing this.
How are you going to get back to Vegas?
As soon as I get out, I can call from my cell phone, which is numbers that I have, and I can book a ticket back home.
Okay. If you want to enter a plea, I'll withhold adjudication. I'll have to impose court costs of $293, but I'll give you 6 months to pay that. Now, I know you're going to be in Vegas, but you need to pay it because if you don't, then it's going to come back to haunt you somewhere.
Absolutely, I appreciate that.
Do you want to accept that plea?
Yes, sir.
Are you willing to give up all the rights and finish with your case?
Yes, sir.
What do you plead, miss? Guilty, not guilty, or no contest?
Guilty.
I'll accept your plea on Miss Fontana. I'll withhold adjudication, $293, 180 days to pay. I got a question for you, miss.
Yes.
It's just not really a serious one. But you live in Vegas and you come to the Seminole Hard Rock to gamble? I don't understand.
No, right? Ridiculous.
Yeah, right. Okay. See you later. Good luck to you.
Thank you.
Linda Gale.
North Broward, Your Honor.
Hi, Miss Gale. You're charged in count 1 with a violation of probation that's based on a warrant. I find probable cause. The bond is $100. If you want to enter a plea, be an adjudication, 3 days, $50 cost of prosecution. I'd give you 6 months, 180 days to pay it, or you can bond out for $100. What would you like?
3 days.
All right. You understand all the rights you're giving up?
Yes.
What do you plead, miss? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea on Miss Gale, case number 17847, MM40. I'll adjudicate you guilty, 3 days. Credit for any time served, $50 cost of prosecution, 180 days to pay. Good luck to you, miss.
Honor, I'm sorry, Miss Gale's case is a VOP.
I understand.
The
The misdemeanor VOP.
Okay, I just thought you had to admit.
Go ahead. What do you want to say?
No, I just thought her plea would have to be either an admission or a denial rather than plead guilty, no contest.
Oh, okay. I understand.
Yeah, I think that's a good point.
You're right. Miss Gale, can I get you to come back? I messed up, so I'm going back to fix this. It's actually a warrant for a violation of probation. They said you didn't complete your community service and you didn't get an HIV test. You wanted, hold on a
Don't
second.
say anything.
Just, well, you tell her not to say anything. She won't answer my question. Let me ask you this, miss.
Well, you can answer the judge's question, but don't say anything else.
All right, here's the deal. You were placed on probation back on the 22nd day of March for 3 months. They say you violated your probation by failing to complete the 60 hours, and get the HIV test. Do you want to admit either one of those, and we can finish with your case?
I do have my HIV test.
Okay.
I just haven't turned it in. I do have a broken back, and they knew that, and I had fallen down the stairs again and re-hurt
So did
my
you do
back.
the 60 hours or not?
I did most of it.
Okay.
I'd like to finish it if I'm able to.
Do you want to admit you didn't finish the part of your probation? It would be an adjudication time, 3 days.
I did not finish my probation.
I'll accept that on 17847. MM10, I'll revoke 3 days. I don't have to charge her any money then. All right, good luck to you, miss.
So what am I?
You're done.
I'm done?
Take care of yourself when you get out.
I can go home today?
Unless you have something else, miss, and I don't know. Yes.
No.
All right.
Yeah.
Judge Gottlieb's doing it. Yes, miss. No. We'll get there. Let me know. Just come stand up when you hear the name, okay? Tanya Jean Netherly. Hi, Miss Netherly. You're charged in count 1, leaving a scene of a crash involving damage. Count 2, leaving a scene of a crash involving damage. Count 3, driving with suspended license. Count 4, careless driving. I find probable cause. I'm going to set your bond as count 1 is 100. Setting your bond at 100. Count 2, 500. Count 3. You can bond out for $700, miss.
Okay, I have a question. First of all, you haven't been able to talk to the public defender
Why?
because he was in your courtroom.
Okay. Well, there was a lot of people today. Maybe he wasn't able to do that.
Right. So my husband.
What can we do about that, Mr. Reedy? Will somebody get back to talk to her, maybe?
I can talk to her if the deputy wants to put her on the phone. I can talk to her right now. Sometimes the timing is sometimes difficult because they can only
Okay.
bring the inmates up at a certain time.
If they can put you on the phone, you can talk to the public defender. Deputy, there a chance she can call the public defender?
Yes.
All right. Thank you so much. Tamala Alves.
She's here, President Judge, I mean, she has private counsel.
Hi, Miss Alves.
Hi.
You're charged with the misdemeanor warrant, case number 1445538 TC20. I'm not sure whose division it is. It's for operating without a valid license. Your bond is $500. I find probable cause. Did he say you had private lawyer?
Yes, I do.
Okay, is your lawyer going to take care of this? You want me to just tell you your bond is $500?
Yes, I already paid for the bill already.
Okay, all right. You should be bonded out soon. Good luck to you.
Thank you so much.
All right. Valentina Lopez.
Judge, I've been advised she bonded.
Okay. She bonded. Manocheka Sinmelis.
I believe Paul Ryan.
Good morning.
Good morning, miss. How are you?
Good, yourself?
Good. You're charged in count 4, which means there's a count 1, 2, and 3. This is an add charge, like another charge. And it's for battery on a police officer. I do find probable cause. I'm setting the bond on $500 on count 4.
It was dropped the last time I came to magistrate court, whatever you call it. They run it concurrent. If you look at it again.
What do you mean run it concurrent?
No, hold on. It says zero bond here.
Right.
Zero bond, but it says concurrent. It was dropped.
Okay, miss, it's not dropped.
Wow.
Okay, your bond is $500 on that count.
On both?
There's another case, I guess, that has counts 1, 2, and 3.
What she's referring to is there were counts of resisting with violence and without violence. She was ROR'd on those counts.
Exactly. Thank you.
So hold on, miss.
She's got a $1,000 bond on a grand theft auto, and as you stated, Your Honor, this is an add charge to those 3 counts.
Okay, you got an ad, grand theft auto, and now you got this one. It's $500.
That's impossible. How can they add it when it was OR? I don't get that. How can
Okay,
that happen?
miss, I can't really discuss all that because I'm not in charge of that. And no matter what they do, I can't tell them what to do because they're the state attorney's office. That's what they've done. They've added an additional charge. Your bond is $500.
Okay.
Okay?
So there's no way that I can pay that right now. So how can we go about fixing that?
Okay, there's people who will talk to you in the jail, miss. Thank you. Maria Lynn Gonzalez. Hi, Miss Gonzalez. This is count 4, 5, and 6. Okay, so they're adding charges to you. They charge burglary of an unoccupied conveyance while unarmed. That's count 4. Count 5, burglary of an unoccupied conveyance while unarmed. Count 6, burglary of an unoccupied conveyance while unarmed. I find probable cause on count 4, setting the bond at $1,000. Count 5, $1,000. Count 6, $1,000. So that's another $3,000 added to your bond, miss. Okay? Good luck to you. Christina Austin.
Miss Austin's here present, Judge Maine.
Hi, Miss Austin. You're charged with a violation of probation based on a warrant. I find probable cause. There's a no bond hold on you. Judge Merrigan is going to see you on June 13th at 8:45 a.m. Good luck to you.
Your Honor, could we recall Miss Netherly? She has some information I think the court should be aware of.
Netherly was.
She's the one that she was.
Used the phone?
Yes.
Okay. All right, Miss Netherly, over at North Broward. Was she at North Broward?
Yes, sir.
Okay. Hi, Miss.
Judge, Miss Netherly has advised me that she's been a resident of Florida for 27 years, and right now her husband is undergoing throat cancer therapy. He's unable to speak, and she is his sole provider. She is currently on disability herself. She's been here in Florida, as I say, for 27 years, living at the same residence for the last 6 years, and she has no prior criminal history, and she also has no way to bond out.
Okay.
In light of the fact that these are misdemeanor charges, and then she has no prior criminal history and strong ties to the community, having lived here for an extensive period of time, I'd ask the court to consider pretrial release for Miss Netherly.
State?
I just need one moment to check
Sure.
the case.
Hold on 1 second, miss. I know you're a little upset and a little nervous. Just hold on a minute, okay? Just a little bit longer.
Okay.
Showing that Ms. Nethery has a pending DUI with property damage and a breath alcohol of a .15 or over. Still pending from 2014. I'm also showing that she previously went through a diversion from 2009 in St. Johns County for 2 counts of leaving the scene of an accident.
I don't know what to say, Mr. Reedy.
I don't know what to say either, Judge. I can
Okay.
only tell you what she told me.
Okay, miss.
I didn't think that St. Johns County thing showed any longer.
Well,
Because I
it
did my,
it did.
they said it was,
Miss, it's not like a credit report. It doesn't go away after 7 years. It's always with you.
so I misunderstood that then.
Okay. Well, then my concern becomes you're innocent until proven guilty in this case, but you've got a prior leaving the scene of an accident and you've got a DUI that's pending. So guess what I'm thinking in my mind? You might not be a good risk to ROR you.
I swear to you, please, Judge, please,
Okay.
I swear to you.
Miss,
I won't-
you can bond out. Respectfully denied.
Thank you.
Ludai Parfait. Parfait. Good morning, miss. You're charged with a violation of probation on a felony charge based on the warrant. I find probable cause. You have a no bond hold from Judge Robinson. He will be seeing you on June 13th at 8:30 a.m. All right? Vanessa Wilson. Hi, Miss Wilson. You're charged with a violation of probation based on a warrant. I find probable cause. There's a no bond hold on you from Judge Cholera. You will see him on June 13th at 8:30 a.m., miss. Good luck to you. Stephanie Rochelle Simon.
Oh, okay. She bonded out, Your Honor.
Thank you, sir. Whitney Shancandace Brown.
She's here present, Judge Maine.
Are you here for Ms. Brown?
Yes, she is, Your
Remember I
Honor.
told you to come on up when you hear her name? Hi, Ms. Brown. You're charging count 1 with burglary of an unoccupied conveyance while unarmed. Count 2, illegal use of a credit card to obtain goods over $300. I find probable cause. I'm going to set your bond at $1,000 on count 1. It's $1,000 on count 2. Your mom is here. Can you see her?
Yes.
Okay. What did you want to tell me, miss?
No, I had got a phone call 7 o'clock this morning, and they had just asked me
Show
some
up.
questions, and
Okay.
so I'm gonna be here.
All right.
Was the one that called her this morning. She did verify the address of her
Okay.
daughter.
Yes.
She did indicate she would be posting the bond. If she's unable to post the bond, I have no problem.
Free trial?
Yeah, she's been arrested before. The cases were dropped. She's had prior arrests for grand theft motor vehicle in 2016, March of this year, petty theft, and they were all no info, Your Honor. So
Okay.
just to be candid with the court, but I did speak with her this morning at the court.
Okay. What about the bond, miss? You going to be able to do that?
Yeah, but she's gonna have to wait till I get paid Friday, cause I don't have it now.
All right. I'm going to let her out on pretrial release.
And then when do she come back?
All right. She's going to have to report the pretrial release
Today.
today. Will she get out in time to report
Yes, she
today?
will, Your Honor.
I
I
won't.
thought it's 8 hours. Okay.
I won't be able to get her out until Friday till I get paid.
Miss,
The judge is
I'm letting
releasing
her
her.
out on pretrial release.
Oh,
She's going to have to report to the miss. I'm going to let you out on pretrial release, but you have to report to the pretrial office as soon as you get out. Give them all your information, and you have to do everything they tell you. They actually hold the keys to the jail. And actually, the keys to the jail are in your hand. If you don't follow all their stuff, you'll be back in jail. But if you follow them, you'll be out on pretrial until your case comes up. All right?
Okay.
All right. Make sure you report. She'll get a chance to talk to you.
I didn't know what that means.
Okay. If
You'll
she,
be able to talk to
I
her.
will. If you can wait until court is over, I'll talk with you for a minute and give you a map and such. So if you want to just sit until court is over, okay?
Sonia Denise Cicero.
She's here, President Maynard.
Hi, Miss Cicero. You're charged in count 1 with burglary or conveyance while unarmed, false identity given to a law enforcement officer. Count 3 and 4 are probation violations, warrants. Count 5 and 6 are burglary of an unoccupied structure while unarmed. Count 7 is a petty theft. Count 8 is illegal use of a credit card. I do find probable cause, miss. Your bond, I'm setting your bond on count 1 at 1,000. Your bond on count 2 is 100. There's a no bond on 3 and 4. On count 5, I'm setting bond at 1,000. Count 6, 1,000. Count 7 is $100, and count 8 is $1,000. So you can bond. Well, your bond is $4,200, but you have a no bond hold on a violation of probation. You're going to see that judge on June 12th at 9 a.m. Good luck to you. Why is it so loud over there? Larissa Denise Melvin.
She's here, President Judge.
Good morning, miss.
Good morning.
Miss Melvin, you're charged in count 1.
Services of public defender.
Okay. You charged with count 2 as a petty theft, which a third or subsequent offense, which means you've had 2 other petty thefts. You also have a probation violation, count 2, probation violation, count 3. I find probable cause. Your bond on the petty theft is $750, and there's a no bond hold on the violation of probation. You will see your judge on June 12th at 8:30 a.m. Okay? Good luck to you. Kimberly Freeman McHenry.
She's here, President Judge. I mean.
Hi, Miss McHenry. You're charged in count 1, abuse of a child without great bodily harm. Count 2, resisting or obstructing a police officer without violence. I do find probable cause. On count 1, I'm setting your bond at $5,500. Count 2, you can bond out for $5,500, miss.
And Your Honor, State would ask for an order at this time of no victim contact until further.
You know, I thought about that, sir, and it's her grandchild. I'll write on there no harmful victim contact. If I change that to harmful victim contact. But it is her grandchild.
Judge.
Yes.
Respectfully, in speaking with Ms. Machinery, she is employed. However, from what she advised me, she has no money in the bank, no property, and no one that could potentially post her bond. She She's asking if, Your Honor, I do understand the nature of count one. She will have her day in court. She wanted to get into facts, but I told her this isn't the appropriate form. I'd be asking if you could consider pretrial, even a stricter form than standard, potentially level 2, which would allow her to go to and from work. Respectfully, that's what we'd be requesting.
Do you have any prior state?
None that I see, Your Honor.
Miss, I find the police report I read very troubling. I don't know if it's true what they said, and I really am not going to ask you what your version of the facts is, but it's very, very troubling, miss. I don't even know what to think about letting you out to even be near that grandchild. I know it's your grandchild, so I put, what's the matter? It's not your grandchild?
Yes.
Okay.
Judge, she's adamant that she's innocent. I keep on advising her she will have her opportunity in court. At this time, it's just a probable cause hearing. That's all it is.
Okay.
That's what I was trying to
All right, I'm going to leave her bond as is. Good luck to you, miss. Brittany Miller.
That's a North Broward medical reset, Your Honor.
Okay. Nicolette Dabar, D-A-H-B-A-R. Good morning, Ms. Dabar. You're charging count 1 with grand theft, count 2 probation violation. I find probable cause on count 1. Your bond is $1,000. You have a no bond hold on the violation of probation. You'll have a hearing on that in front of your judge on June 13th at 8:30 a.m. Good luck to you.
Good luck,
Joey Harris.
June 13th, 8:30 a.m.
Yeah, but there's no point of bonding after this one, right?
Hi, Mr. Harris. You're charging count 1. It's a capias or a warrant for driving while license suspended. Count 2 is a writ of arrest. I do find probable cause. Your bond on the driving while license suspended from Judge Backman is $2,000, and the writ of arrest requires you to post $465. That part is a civil part. That's the money you'd have to post in order to get out, and your bond is $2,000 on the other one. All right, I can't offer you a plea at this time, sir. Good luck to you.
I know you said you wouldn't offer a plea. This is my only. He's going to try and see what he can do as far as his family helping him bond out. Whatever funds he gets, I would ask him to apply it towards the writ of arrest. That's why I would be asking you if you would consider resolving count 1, so therefore he wouldn't have to bond and use those funds for the child support.
Sure.
Just also to advise the court, and it's probably on his driving record. Mr. Harris also has a warrant at a Dade County from this year for failing to appear in court on a DWLS.
Okay.
$1,500 bond.
Okay. I'll lower his bond to $1,000 on the warrant. That's it.
Yes, Judge, thank you.
All right. Joseph Batten.
Judge, I've been advised it's a medical reset.
Thank you, sir. Christoph Tullock. State, I need you to look at this one.
Yeah, sure.
Mr. Reedy.
Yeah,
Mr. Tullock, you're charged in count 1 with possession of cannabis less than 20 grams. I have looked through the probable cause affidavit. I do not see where it was Valtoxed at all.
There's no mention of a field test, Judge.
Okay. So I will find no probable cause on count 1, 48 hours to perfect, and I'll ROR him on the count.
Your Honor, I'm not going to ask for any time then.
No?
Well, he'll be out before the 48 hours.
Okay.
So.
All right, so I'll ROR him. No probable cause. Paul Joseph Addison. Hi, Mr. Addison. You're charged with it's a warrant for criminal mischief. I find probable cause. Your bond is $1,000 on that, sir. You're gonna,
Hospital.
pardon me?
I was in the hospital.
Okay, all right. Well, you're gonna have to go see that judge, sir. Your bond is $1,000. You can bond out for that amount.
Judge, Mr. Addison did indicate to me that he might be interested in trying to resolve the case if possible.
It's a criminal mischief, so there's restitution gonna be involved, so respectfully, I won't do that.
All right, good luck, Mr. Addison.
Tuvalase Chambers. I don't even think that's close. Mr. Chambers, you're charged with a misdemeanor warrant, $1,000. I find probable cause. It's going to be set in the division, I believe. I'm trying to find what the charge is.
It's a domestic violence battery.
It's a battery. You're going to have to see that judge, sir. Your bond is $1,000.
Judge,
right.
normally I wouldn't say much on cases. There's a reason why. My understanding is he was in prison for 4 years. Yesterday was his release date. This is the only offense that's pending. This is a misdemeanor offense, and he advised me that he was in state custody when he missed court. I believe there is potentially a motion to dismiss, but this isn't the appropriate form because of statute of limitations. Considering he was in custody, he just got released from prison. He hasn't been working in over 4 years because he's been serving time. Would you consider an ROR on this case, Judge? He would still have to come to court, and still his attorney, his public defender, would have to submit a motion to have it dismissed. But I'm asking at this time, would you consider an ROR?
State?
Your Honor, my position is this is out of a domestic violence division. Judge McHugh would have to hear the matter of whether.
Yeah, it is out of domestic violence, so he can go see Judge McHugh. All right? It's already set for, well, it's going to be set. It'll be set soon. She's always there. All right? I'll respectfully deny that. Jeffrey Lee Edwards. Mr. Edwards, you're charged at count 1 with a petty theft. I find probable cause. Your bond is $25. You can bond out for that amount, or if you want to finish with your case today, it would be an adjudication, 3 days, $50 cost of prosecution. I'd give you 180 days to pay that. Which would you like to do, sir?
Can I resolve it?
You want to resolve it? You understand all the rights you'd be giving up?
Yes.
And what do you plead? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea on Mr. Edwards. I'll adjudicate him guilty, 3 days. Credit for any time served, $50 cost of prosecution, 180 days to pay. No return to that store, sir.
Okay.
All right? Good luck to you. Rakeem Anthony Johnson. Mr. Johnson, you charge at count 1, driving while your license is suspended or revoked. Count 2 is a warrant for a driving while license suspended. I find probable cause. Your bond on count 1 is $100. Your bond on count 2 is $250. You can bond out for $350, sir. All right. Good luck to you. Jose Ramon Obando.
Oh, Judge, I've been advised to bond it.
Okay. All right. I believe we are to the felonies now. I believe. Sometimes they mix them in. I'll do my best. Rashim Jamal Chamberlain.
I've been advised Mr. Chamberlain is in regular court, Judge.
Okay, thank you. Keon Alexander Underwood.
Mr. Underwood, come on up, please.
Mr. Underwood, you charge and count. These are extra charges. I guess that's the best way to say it. You already have some charges. I keeping you awake, sir? I give you some extra charges here. Count 7, burglary of an unoccupied conveyance while unarmed. Count 8, grand theft. Count 9, probation violation. Count 10, probation violation. Count 11, 12, 13, and 14 are burglaries of an unoccupied conveyance while unarmed. I find probable cause. Your bond on count 7 is $1,000. Bond on count 8 is $1,000. There's a no bond hold on you on counts 9 and 10. On 11, 12, 13, and 14, I'm going to set a $1,000 bond on each one. So you got the no bond hold and an additional $6,000. All right, sir, you will see your judge on June 12th at 8:30. Good luck to you.
Thank you, sir. He's very happy with that news, Judge.
I told you he had a sense of humor, didn't I? Noel Rodriguez Ruba Lacaba.
North Broward, Judge.
Yes. Oh, can I see? Maybe I missed a page. Let me see. Oh my gosh, I did miss a page. Can we get Mr. Underwood back? And we'll get the interpreter very shortly.
Domestic.
Can we get Mr. Underwood back?
Mr. Underwood. Mr. Underwood, come on. They're getting him from the back room, Judge.
Tell him I'm sorry, I just forgot
Okay, no problem.
to turn the page.
He's back, Judge. Coming in.
Hey, Mr. Underwood, I made a mistake, okay? You had another page of charges that I didn't read. So I have to tell you what they are. Count 15 is burglary of an unoccupied conveyance while unarmed. Count 16, grand theft. Count 17, grand theft. Count 18, petty theft. Count 19, petty theft. Count 20, illegal use of a credit card. Count 21 and 22 are violations of probation. Your bond on count 15, I'm setting at 1,000. Bond count 16, 1,000. Bond on count 17, 1,100. Count 18, 100. Count 19, 1,000. Count 20. And there's no bond holds on those other ones. So you're going to see that judge again like I told you on the 12th. Good luck to you, sir.
So how much am I worth?
A lot of money. Lots of money. All right, I'll set aside this one for the interpreter. Russell Brown.
Mr. Brown, come on up, please.
Hi, Mr. Brown. You're charged with a grand theft auto. I find probable cause. That's based on a warrant from Judge Shear. You will be seeing Judge Shear, and you can bond out for $1,000 if you'd like, sir. All right? Good luck to you.
See you soon.
Ashton Lang.
Mr. Lane, come on up, please.
Hi, Mr. Lang. You're charged with a violation of probation that's based on a warrant. I find probable cause. Judge Fine has set a no bond hold on you, sir. He will be seeing you on June 12th at 8:45 a.m. All right? Good luck to you. Jacory Payne Blunt. Mr. Blunt, you're charged at count 1 with it's a warrant for a misdemeanor. I find probable cause. On count 2, it's a violation of probation, a felony. I find probable cause based on the warrant. Your bond on count 1 for the misdemeanor is $250. Judge Duffy has a no bond hold on you. You'll be seeing her on June 13th at 9 o'clock. All right? Good luck to you. Franklin Montoya.
Morning, Your Honor.
Good morning, Mr. Montoya. You have a warrant that's actually out of my division from 2011, and you have another warrant on a felony. I find probable cause. Your bond on count 1 is $500. There's a no bond hold on you. On the felony, you're going to go ahead and see your judge. Well, actually, you're going to see me on the 12th at 11 a.m. I don't know about the felony. All right? Good luck to you.
Yes, sir.
Desmond Daniels. Mr. Daniels, good morning. You're charged at count 1 with a violation of probation. Based on a warrant, I find probable cause. Your bond there's no bond hold. You're going to see Judge Siegel on June 12th at 8:30 a.m., okay? Good luck to you. Alfredo Martinez.
North Broward, Judge.
Hi, Mr. Martinez. You're charged in count 1 with a violation of probation. That's based on a warrant. I find probable cause. Judge Bober is going to see you. It's a no bond hold. You'll see Judge Bober on June 12th at 9 a.m. All right? Good luck to you. Daniel Herrera. Hi, Mr. Herrera. You're charged with a violation of probation that's based on a warrant. I find probable cause. Judge Cohen has a no bond hold on you, sir. You're going to see him on June 14th at 9:45. Good luck to you. Sure. Robert Stephen Tradella.
Yes, sir.
Mr. Tradella, you're charged in count 1 with a violation of probation that's based on a warrant. I find probable cause. That's a no bond hold. Judge Robinson's going to see you on June 13th at 8:30.
Thank you.
All right, you're welcome, sir. Troy Brown.
Judge, we'd be waiving formal reading of the charges.
Okay.
And, Your Honor, if I could,
Yes.
assume the court finds PC, if I could advise you of his priors before you set
I do
bond.
find probable cause.
Just to advise the court, Mr. Brown in 2011 was convicted of 3 counts of failing to register the same offense.
Okay.
sentenced to 4 years state prison. 2011, again, convicted of failing to register, 4 years state prison. 2011, trafficking in MDMA, 4 years state prison. I believe the underlying offense that it qualified him was out of another county or
Okay.
state.
Okay. Anything, Mr. Romero, Mr. Reedy?
Judge, as far as his financial resources, I just want to let you know, he works for Swenson's. It's a restaurant. He's a cook making $15 an hour. Financially, though, he has no money and make no property, so I'd ask you to also take into consideration his financial resources.
Okay. I'm going to set his bond at $10,000 on count 1, $10,000 on count 2. You can bond out for $20,000. Okay. James Barone. Hi, Mr. Barone. You're charged in count 1 a violation of probation that's based on a warrant from Judge Porth. He would like to see you. There's a no bond hold. He'll see you on June 16th at 8:30, sir.
Can I ask you something?
Well, just don't talk about the facts, but you can ask me something.
Okay, my daughter's having surgery. She's 5 years old. I would like to be out there to see her.
When's she having surgery?
Today at 11 o'clock on her tonsils.
Well, sir, I doubt that's going to happen, to be honest with you, because they have to get a motion in front of the judge, okay? And it's already 9:20, okay. Taro Benaby?
Mr. Benby, come on up. I already know I got no gun. You're right.
Good morning, sir. You charged, I'm good. You're charged with count 1, touch or strike battery. Count 2, 3, 4, and 5 are violations of probation. I find probable cause on all of them. Your bond on the new battery is $1,000. No bond on the other one. No victim contact on count 1. And your violation of probation hearing, you're going to see Judge Robinson on June 13th at 8:30 a.m. Good luck to you.
Yes, sir.
Joshua Estefan Vasquez.
Judge, you can find Sir Public.
All right. Good morning, Mr. Vasquez.
Yes, hi.
Good morning, Your Honor.
You're here with the charge of a violation of probation that's based on a warrant from Judge Merrigan. I find probable cause. Somebody's here for you. Yes, sir?
I'm his father, Angel Vasquez.
Yes,
and,
sir.
He also has his lawyer, Mikey.
Who?
Mikey Rock, R-O-C-Q-U-E.
Mickey Rope.
There you go.
Yes, sir.
But he's at another court, in another room, but he said he will be here. My question, Your Honor, is what was he arrested for? I know there was probation.
Let me look.
Thank you. I appreciate it for your time.
Could you just give her a message for me and ask her to call me as soon as she's available?
It looks like they came to your house because there was a warrant for a violation of probation. It says that he was placed on community control on the 14th day of February, and he violated that by failing to remain confined to his approved residence. States the offender was away from his residence located at 404 Southwest 77th Avenue on March 19th at 8:59 without prior approval. Apparently, the officer came to the house to visit. I don't know if that's true. I just know that's what they say.
Can I make a comment on that, sir?
Sir, it's not going to help. I can't do anything about this case. It's a felony case.
I understand, but I just
You just feel like you need to say something.
just need to
You
say
know,
it.
everything is being recorded. I want you to understand that. So if you say something that's not helpful to your son, it's going to be recorded and they're going to use it.
No, he's never been in trouble. That day, the May 19th, he lives with my ex-wife. Because she has video cameras on the house. The problem is when she went to review it last night, it goes back 30 days. But we have witness. She was there. She stepped out because she was going to the beach, but he was there the whole time. He was there on the 19th.
Okay. Well, it's not whether she was there; it was
Right.
whether he was there.
He was there the whole time, Your Honor.
Well, sir, I guess that's something you'll have to show to Judge Merrigan.
Okay, so what's going to be?
There's a no bond hold. He'll have a hearing in front of Judge Merrigan on June 13th,
So we got to wait to June 13th?
8:45 a.m.
Okay.
All right. Thank you for coming, though. All right, sir. Judge Merrigan will see you on that day. Michael Canning.
Mr. Kenny is approaching, Judge.
Good morning, Mr. Canning. You're charging count one with the murder not premeditated during a specific felony. I find probable cause. Anything from the state?
Your Honor, this is a punishable by life offense. The state would be seeking a no bond hold.
Okay. Mr. Reedy?
At this time, the defense would be asking the court to conduct an Arthur hearing, and the standard to hold Mr. Canning without bond, which is the most severe sanction the court can impose for someone who is presumed innocent, is the proof is evident and the presumption of guilt is great. The only evidence produced by the state at this point in time is a probable cause affidavit. They've called no witnesses, introduced no physical evidence. They have not met the burden of proof evident presumption great, and we would ask the court, based on the fact that that standard is the highest standard we have, far beyond proof beyond a reasonable doubt, that this court set bond for Mr. Canning. Also, I'd point out that this is kind of a tragic situation. I mean, I don't know exactly what happened, but the victim is Mr. Canning's brother. Looks like they had some type of an argument, and this was the result. It is something that is not premeditated, which would indicate, I think, to this court that Mr. Canning is less of a threat to the community than the severe outcome of the incident resulted in. I think he should have a bond, Judge.
And what would you be suggesting as a bond?
How much bond can you afford, Mr. Canning?
How much do you think your family are looking for? Total with the GPS, 20,000 with the GPS. Yeah.
Judge, respectfully, Mr. Canning would be asking if you would consider $20,000 with some form of pretrial level 1 or level 2, anything that would alleviate any of the court's concerns, Judge.
Your Honor, the state would ask to be heard before.
Sure. I was just about to say state. Okay.
Reading your mind. Judge, first off, as far as the evidence, and one, the defense argument that the court cannot or should not find proof evident presumption grade because the state has only provided a probable cause affidavit.
I can do that. Get
Okay.
on to what you want for a bond.
Well, Your Honor,
Tell me his priors, anything like that.
Your Honor, I'm going to be requesting no bond. I believe that there is proof evident or presumption grade on a punishable by life offense. Your Honor, he confessed to stabbing, killing his brother. His claims that this was in self-defense are refuted by the physical evidence. It's not supported by the evidence, Your Honor.
Does he have any priors?
I'm checking that right now, Your Honor.
Okay. Honestly, I really thought you would have checked that out before, but I don't know what happened. Okay. Mr. Reed, you did call for an interpreter, though, right? At some point? Okay. Thank you.
2013 out of Maitland, felony possession of controlled substance, possession of drug paraphernalia. 2009 out of Winter Park, possession of cocaine, possession of drug paraphernalia. No additional priors, Your Honor. However, because this is a murder case, if the court were inclined to set a bond, the state would be asking for a $500,000 bond, pretrial release with a GPS monitor level 1.
Okay.
That would be tantamount to no bond, Judge.
All right, what I'm going to do is I'm going to say that I have read the probable cause affidavit. I think from the four corners of that, I can find probable cause. I can also find proof evident, presumption great. There is a question about the defendant's version of the facts, which may put it in the light of a self-defense case. I'm not sure because that's what the police report said. That was written by the police officer. I'm not really sure of the version that was out there. Even though I find proof evident presumption great, I'm going to set his bond at $50,000. I'm also going to order that he have a GPS monitor, the highest level available on pretrial release.
Your Honor, typically there is a cost of $5 per day for the monitoring fee. If the court finds it exigent, then that fee of $5 per day could be waived.
I'll waive that $5 fee. Okay. Good luck to you, sir.
Thank you, Judge.
Judge, two other things before we finish. If Mr. Canning doesn't find out, I would ask you if you could sign a photo order allowing us to photograph his injuries.
Sure.
And number two, I'd be invoking his constitutional rights, right to remain silent, not be questioned by law enforcement without his counsel.
You get me that order and I'll sign it. All right? Okay.
That document will be filed probably by the end of the day with the court invoking Mr. Canning's right
Yes,
to remain silent.
no one from law enforcement to go out and talk to him about his case.
And Your Honor, just for the record, the state would object to what the court has
Noted.
essentially conducted an Arthur hearing today, and the state would object to an Arthur hearing being conducted at first appearance.
Oh, this time you object?
Well, I'm objecting to the.
Okay. No, I got it. That's why they pay me the big bucks. Okay. Jarvis Jamero Wilkins. But let me say for the record, I did conduct an Arthur hearing, and I found proof, evident, presumption great, but I set a bond anyway, just for the record. Jarvis Jamero Wilkins. Sir, you're charged with a violation of probation that's based on a warrant. I find probable cause. There's a no bond hold on you, sir, in front of Judge Cohen. You're going to see him on June 14th at 9:45 a.m.
Good luck, sir.
Ryan Debbie? How do you say that, Mr. Reedy? DB, there you go. Sir, you're charged in count 1 with an accessory after the fact of first-degree felony. Count 2, accessory after the fact of first-degree felony. I'm thinking that's going to say murder on it. Accessory after the fact of first-degree felony. 3 counts. I find probable cause. That's in front of Judge Robinson. There's a no-bond hold on you on all 3 counts, sir.
Judge, I think that this is a outstanding warrant. I don't think that Mr. Debe has had an opportunity to have the facts of the case considered or defense issues considered in front of any other judge up to this point.
Go ahead.
I need a moment to read it. I just got handed it at the beginning of the docket.
Well, yeah, it was a long document. I read it all myself, so I'm aware of it. But I can put it on recall and give you a chance to do that.
That'd be fine, Judge. If you
All
wouldn't
right.
mind.
Well, I'll hold Mr. Debe on recall. Nelson Lockhart.
Mr. Lockhart, your present, Judge?
Mr. Lockhart, you're charged in count 1 on a warrant for a felony. It's for an aggravated battery. On a pregnant victim, I believe. Let me make sure. I don't want to misstate that.
I believe it's great bodily harm.
Great bodily harm, I'm sorry. Count 2 is a robbery by sudden snatching without a firearm or weapon, and count 3 is a battery. Subsequent offense, I find probable cause. Upsetting your bond, well, there's a no bond hold on the capious warrant. Is that one that I would consider at this time, State? Is that one of the ones that comes in and I have to set the bond?
Hold on one second. Yes, Your Honor, he is.
Would you think that, Mr. Reedy?
Yes, Your Honor. I believe you do
Okay.
have to
All right.
consider
Count
bond
1
for
is not for magistrates.
Mr.
Count
Lockhart.
3, he's entitled to a bond.
Yeah, count 3, he is entitled to a bond, Judge.
Okay, I'm setting his bond at $5,000 on that one, $1,000 on count 2, so the other one's a no bond hold still on count 1. Okay. No victim contact. Eric Milton Loy. Hi.
He's here, President, Judge, I mean.
All right, Mr. Loy, you're charged of count 1, grand theft auto, count 2, violation of probation. I find probable cause. Your bond on count 1, the grand theft, is $1,000. There's a no bond hold on you for the probation violation. You're going to see your judge on June 12th at 8:30 a.m. We have the Spanish interpreter here. We're coming back on Mr. Rodriguez Rubal Cava, who I believe is at the North Broward.
Good morning, Your Honor. Spanish interpreter is present.
Okay, give me a second. Can you raise your right hand?
Yes, Your Honor.
Do you solemnly swear to tell the truth, the whole truth, nothing but the truth?
Me toca a mí, señor. Yes, Your Honor. Luz Angela Lopez, LOPEZ, certified Spanish interpreter for the courthouse.
Do you solemnly swear to translate from English to Spanish, Spanish to English, all the proceedings to be had before you and provide an accurate translation to the best of your ability?
I will, Your Honor. Luis Angelo Lopez.
Are you Mr. Noel Rodriguez Rubal Cava?
Usted es el señor, I am so sorry, Raúl, Your Honor?
Rodriguez
Raúl Rodríguez.
Rabal
Rabal
Cava.
Cava? Yes.
Sir, you're charged with a violation of probation.
Señor, lo acusan de haber quebrantado su libertad vigilada probatoria.
That's based on a warrant by Judge Cohen.
Esto está basado en una orden de captura que expidió el señor juez Cohen.
I find probable cause.
Encuentro motivo fundado para la detención.
You will see Judge Cohen
Verá al señor juez
on June 12th
el 12 de junio
at 9:45
a las
a.m.
9:45 de la mañana.
Okay?
¿De acuerdo? Okay.
Okay. Thank you, miss.
Thank you, Your Honor. Have a good day. May the interpreter inquire?
Sure.
¿Hay alguien más que necesite que se le interprete su caso en español?
No takers. Thank you.
Thank you.
Your Honor?
Yes.
I'm sorry, before we move on to the next case, and I'm not trying to belabor the issue, I just want to make a record on
Sure.
the State v. Michael Canning.
Yes.
I know the state objected to
Right.
hearing. And also, Your Honor, the basis for the objection is we didn't receive notice. The victim's family, and I understand that's also his family, but it's the victim's family also, didn't have an opportunity to be notified, to be present, to address the court, which I believe is their right under the Florida Constitution, Your Honor.
Okay. All
I
right.
don't know if the court, under that
Noted for
basis,
the
if the
record.
court will reconsider. Okay, thank you.
All right. Joseph Antonio Sinclair. Mr. Sinclair, you're charged in count 1, possession of cannabis less than 20 grams. Count 2, driving while license suspended. Count 3, failing to wear a seatbelt. Count 4, failing to stay in a single lane. Count 5, probation violation. I find probable cause. Your bond on count 1, the cannabis, is $100. $500 on the driving while license suspended. There's a no bond hold on count 5. So other than the $600, you're going to have to see your judge on June 12th at 8:30 a.m. for that violation of probation. Good luck to you, sir. Terrence Levon Peterson.
Mr. Peterson, come on up.
Good morning, sir. Mr. Peterson, you're charged in count 1, possession of cannabis less than 20 grams. Count 2, possession of THC. Count 3, possession of drug paraphernalia. I find probable cause. Your bond on count 1 is $1,000. Your bond on count 2 is $1,000. Your bond on count 3 is $100. You can bond out for $2,100. All right?
I have a question.
Okay.
That lady that was here from Las Vegas, she's with me. We're friends. Basically, I'm making sure she gets home. I was in the process of getting her ticket when everything happened. I was going to see if you could reconsider maybe giving me an R, possibly 2, so that way I can make sure that not only she gets home, I can take care of my stuff also too outside of here.
Check them out pre-trial.
Who's this?
Okay. All right, sir. Okay, sir. All right, sir, here's what I heard. You refused to speak to pre-trial when they were in there. You refused to. Now, I'm not going to quibble with you. That's what they're telling me. Second thing is you had an attempted murder case out of California. You have a pending felony, and there's another felony that you had already pled to in 2014. So your bond is $2,000, as I told you, sir. All right, good luck to you. Jonathan Marius.
Mr. Mary? Jonathan Mary?
Mr. Marius, you're charging count 1 with a violation of community control, count 2 violation of community control. Based on a warrant, I find probable cause. There's a no bond hold for you on the count 2, and there's a $2,000 hold for you on count 1. You're going to see Judge Cholera on June 13th at 8:30 a.m. Good luck to you.
June 13th, 8:30.
Clinton Worley.
Mr. Worley, is the approaching judge. We'd be waiting for a reading of the charge.
Okay. Mr. Worley, I find probable cause. I'm setting your bond at $5,000, sir. You can bond out for that amount.
What was the bond amount, Judge? I'm sorry.
5,000.
Thank you, Judge.
Ronaldo Cruz.
Mr. Cruz. Ronaldo Cruz, come on up, please.
Hi, Mr. Cruz, you're charged in count 1 with burglary of an unoccupied conveyance while unarmed. Count 2, illegal use of a credit card. Count 3, grand theft. Count 4, grand theft auto. Count 5, abuse of a child without great bodily harm. Count 6, resisting an officer without violence. Count 3, fleeing and eluding an officer at high speed. And count 8, reckless driving. I find probable cause. On count 1, I'm setting your bond at $1,000. Count 2 is $1,000. Count 3 is $1,000. Count 4 is $1,000. On count 5, I'm setting it at $5,000. 100 count 6, 1,000 count 7, and 100 count 8. So your bond is.
There's more.
Pardon me? Oh. All right, hold on. You're also charged with driving with a suspended license, burglary of an unoccupied conveyance while unarmed, petty theft, illegal use of a credit card 2 times within 6 months. You have an out-of-county hold, no bond hold. I'm going to need a calculator to figure this out, but I'll try, sir. Yes. I didn't tell you what? I said 1,000 on count 7, the fleeing. Count 10 is 1,000. Are you going to be able to figure it out for me? No? Okay. Hold on. 1, 2, 3, 4, 5, 6, 7. 7,225, and then there's that no bond hold. That's an out-of-county hold for you. I'm not sure which county it's from. Let me see if I can figure it out. Volusia County. All right. Good luck to you, sir.
Your Honor, and before we move on,
Yes.
Mr. Romero, wait, could you have him? And I understand that the child is his child, but that being said, he did put his child in great safety and great risk, having his child in his custody while fleeing from police, driving and by foot. Your Honor, at least for the immediate future, for the protection of the child, we would be asking for no victim contact.
Thank you. Bye.
I'll respectfully deny that at this time. No harmful contact. Robert Noel Miller.
Thank you.
I'll write that on there.
Mr. Miller, is that North Broward Judge?
Hi, Mr. Miller, you're charged at count 1 with a violation of probation, count 2 violation of probation. Those are based on warrants. I find probable cause. You have a no bond hold for Judge Singal. You will see Judge Singal on June 13th at 8:30. Good luck to you. Byron Lizarde Chavarria.
Judge, I've been advised he's bonded.
Okay.
Oh, wait, hold on. Look. Yeah, they confirmed it.
Well, good, because you're only allowed one mistake, Mr. Romero. Antoine Walden. I'm only kidding, Mr. Romero, in case anybody took me serious. Sir, you're charged in count 1, Mr. Walden, of a possession of a forged driver's license. I find probable cause. Your bond is $1,000. You can bond out for that amount, sir.
Judge, do I qualify for pre-trial?
Let me ask. Pre-trial on Mr. Walden. You went to talk to him and he refused?
Not me personally.
Okay.
But I do have it where it says.
All right. You missed out, sir, respectfully. They went to interview you and you didn't talk to them. So.
Oh, I didn't know the difference on. That's what I was asking around.
Yeah.
I didn't know the difference between pre-trial and bail. And I kept out.
Well, the state attorney doesn't have people in there asking you questions, so it's usually only people in there to help you. Okay. Sorry about that. You can bond out for $1,000. Adam Scott Crapo.
Mr. Crapo, come on up, please. Crapo? How do you pronounce your last name? I'm sorry. Crapo.
Mr. Crapo, you're charged in count 1 with touch or strike battery, count 2, abuse of an elderly or disabled adult without great bodily harm. I find probable cause. Your bond on count 1 is $1,000. Your bond on count 2 is going to be $10,000, sir, and you're going to have no victim contact. Good luck to you. You can bond out for $11,000.
Judge, does it state the victim's name in this report?
Let me look.
I mean, not his name, his age.
It's not based on his age, it's based on he's disabled.
Right.
Okay, all right then.
Thank you, Mr. Reedy and sir. Thank you. All right. Guillermo Adon Sosa Peralta. Good morning, sir. You're charged in count 1 with grand theft, count 2 probation violation, count 3 probation violation. I find probable cause. Your bond on count 1 is $1,000. There's a no bond hold for you on those 2 warrants. You're going to see Judge Siegel on June 12th at 8:30. Good luck to you. Devon Maurice Gray. Mr. Gray, you're charged with aggravated battery on a person that you knew or should have known was pregnant. I find probable cause. I set your bond at $10,000, sir. You're to have no victim contact. Good luck to you. $10,000.
I'm not eligible for pre-trial.
Sir, if you were, I wouldn't sign the order. Okay?
Oh, okay.
Good luck to you.
Thank you.
Mohammed Omar.
Mr. Muhammad Omar is here present, Judge.
Sir, you're charged in count 1, displaying a firearm during a felony, discharging a firearm in public, count 3, possession with intent to sell, manufacture, deliver cannabis, and drug paraphernalia.
As to count 3, Judge, I have an issue with probable cause on that. I mean, they state the amount, and they state that there was a scale, which is not that unusual and does not necessarily in and of itself indicate an intent to sell. They're not specific about how this was packaged as to whether there were individual baggies or how it was in this glass jar. So I don't think there's probable cause to establish the idea that this was possession with intent to sell.
Let me read it again. State?
One moment, Your Honor.
Okay. It's the last paragraph.
Yes.
I won't agree with you on the scale, Mr. Reedy. I'm looking at the other part.
Okay.
Your Honor, for probable cause purposes, I think there's enough that it's for more than just personal use. Obviously, if it were to go to trial on a higher standard, that might be a different story, but for probable cause purposes.
12 grams is not out of the range of personal use, Judge.
Okay.
Judge, the only other thing I'd actually take into consideration, my understanding, this is his first arrest ever in his life.
Well, that's a different issue than what we're talking about now.
Right.
So I'm reading that it had a weight of 12.6 grams, including packaging. It should be noted the amount of the suspect cannabis was in possession and combined with it was packaged and the digital scale do not coincide with normal personal use. I'll agree with that respectfully, and I'll find probable cause. Your bond is $1,000 on count 1, 100 count 2, 1,000 count 3. Possession of drug paraphernalia, that's $100, so that's $2,200. Pre-trial, was he interviewed? Mr. Omar?
Great.
Right. Okay. All right. I agree with pretrial at this point. His bond is $2,200. Respectfully, I'm not going to grant a pretrial based on the nature of the charges. Okay. Travis Xavier McLarty.
Mr. McCarty.
Good morning, sir. You're charged in count 1, fraudulent use or possession of an ID of another without consent. Count 2, I have a question on, and count 3 is uttering a false bank bill, check, or draft note. I do find probable cause on that. State, I'm a little confused. Fraudulent use of an ID of 10 to 20 others without consent. I'm not sure what that is, but I notice it's a higher bond amount. So I'm guessing it must be a higher charge.
Yes, Your Honor. Just reading through. Same statute book. I'm just checking to see, Your Honor, if it has, under the statute, it might have to do with the amount of IDs or the amount of money.
Right, but I only see he had John Lennon's ID.
No, I'm saying, I'm just checking the statute real
Okay,
quick.
all
'cause-
right, I'll let you look.
The order will contact the order.
Yes.
Under Florida statute 817.568 2B,
Okay.
it covers either 10 or more individuals but fewer than 20, or if the fraud perpetrated is $5,000 or more.
Okay.
It just, they just.
All right. Mr. Reedy, you want to be heard?
I believe the state's correct on that,
Okay.
Judge.
All right, so I'm scratching out all that, no probable cause on count 2. I'm finding probable cause on counts 1, 2, and 3. His bond is $1,000 on count 1, $3,500 count 2, $1,000 count 3, for a total of $5,500. You can bond out for $5,500, sir.
Thank you, Judge.
All right. Jacob Miller. Hi, Mr. Miller.
Yes, sir.
You charge count 1 with burglary of an unoccupied conveyance, which is a car while unarmed, and trespassing of an unoccupied structure or conveyance. I find probable cause. Your bond is $1,000 count 1. I'm setting it at $100 count 2. You can bond out for $1,100, sir. Good luck to you.
Okay. Thank you.
Sure. Rodney Lorenzo Hudson.
Mr. Hudson, to your presence.
Hi, Mr. Hudson. You're charged with count 1 violation of probation that's based on a warrant. I find probable cause. There's a no bond hold on you from Judge Duffy. You'll be seeing her on June 13th at 9 a.m. Good luck to you. LaShawn Spriggs.
Your Honor, I'll wait for the court
No,
to
go
find.
ahead.
Your Honor, on these cases, these are a change of charges, but Judge Pohl, when he came through originally, my understanding, that's why it says court order on the booking.
Right.
He revoked his bond on these cases, I believe.
You know anything different, Mr. Reedy?
I know he's got in excess of 60 current charges. Many of them are no bond.
Okay. All right, Mr. Spriggs, the judge prior to me had set a no bond hold on count 11, 12, 13, 17, and 18, so it's going to be a no bond hold on those. My understanding is you have a lot of other charges, sir. I'm sure whoever represents you will have note of all of them, okay? Good luck to you. You don't understand? You already saw Judge Pohl. He was a judge you saw here on the TV court here, and he put a no bond hold on you, and then they were checking the charges or something. They just came back, so it's still a no bond hold. Same thing. I just wanted to let you know. And they've informed me you have about 60 charges going on, so you'll be aware of all of them. Okay?
Okay.
Good luck to you. Quincy White.
Mr. White's here present, Judge of Maine. I advise him not to talk about the facts of the case.
All right. Hi, Mr. White.
How you doing, Your Honor?
No. Hold on a minute, okay? Your lawyer doesn't want you to talk. We'll find out whether you should or not. I need to read you the charges first, okay? Because we've been trying to get you here. I think you've been ill or something, so we finally got you here.
Yeah, detoxing.
All right. So can you listen for a minute?
Yes, sir.
All right. You charge count 1, possession with intent to sell, manufacture, deliver cocaine, resisting an officer without violence. There's 2 county ordinance violations and a corruption by threat to a public servant or family. I find probable cause. Your bond on count 1 is $2,500, 100 count 2, 100 count 3. 25 count 4, and 1,000 count 5. So your bond is $3,725. Now, your lawyer says you shouldn't talk about the facts of your case. I kind of agree with them. They know what they're doing. He's blocking you out. I can't hear you.
The only thing Mr. White has repeatedly asked me to ask your court if you would consider pretrial release on his behalf.
Okay, respectfully not, based on the nature of the charges.
Can I say something now, please?
Don't talk about the facts of the case.
I'm not talking about the facts of the case, bro. I'm talking about reality. I don't see how they charge me with intent because the police ran down on me about an open container. And because
about the open container, it's a municipal ordinance. I know it's out of the city of Fort Lauderdale.
But
would you consider appointing Mr. McLaurin's law firm to represent Mr. White since he did fill an application with the PDC and he is indigent?
I will appoint. Well, let me see. Are they both out of Fort Lauderdale? There's two of them. He's got a possession of marijuana and an open container. I'll appoint Mr. McLaurin's firm on. Is it two separate cases?
can I get ROR?
No, sir.
I wasn't.
I will appoint. It looks like I can't tell if it's the same case. Can anybody? Is it the same case? All right. So I'll appoint Mr. McLaurin's to represent him on a municipal ordinance case. I'll sign an order for that.
Your Honor, may you please at least lower the bond on the intent to sell because
Give me 1 second.
He has an open case. He was supposed to be arraigned on the open case.
What's his open case for?
Possession of cocaine and possession of
Controlled substance.
substitute cathinone.
All right, Mr. White. Respectfully, I'm not going to lower your bond. Respectfully, I'm not going to. What?
why? I didn't.
I'm about to tell you why. I was going to tell you what I'm doing first, and I'm not going to consider you for pretrial release. You have another case, possession of cocaine. You were supposed to be arraigned on that today. And what was the other count on that?
Substituted cathinones.
And there's another felony charge, I believe, pending with that. So respectfully, I'm not going to give you pretrial. Respectfully, I'm not going to lower your bond. I can't hear you. He's got his finger on the button.
Talk to the man. I got time served on drug court, and I was in drug court because I do drugs, bro. They ran down on me.
I'm not your bruh. I'm not your bruh.
It's also on probation.
I can't hear a word you're saying.
Can you stop doing that? I don't do drugs. I do drugs. Okay? I don't sell no drugs. They ran down on me about an open container. They found cocaine.
Sir, I'm going to save you from yourself. The public defender's trying to do their job. Thank you. Good luck to you. If we have to remove them, please remove them. I'm so glad I couldn't hear that because I read your lips. Tylum, Xavier, Mack. Good job, Mr. Romero.
It's a medical loan, Judge.
What's medical loan?
I think so.
Jamar Williams.
I know, but I don't know when he's coming back.
Hi, Mr. Williams. You're charged in count 1 with a burglary of an unoccupied conveyance. Weren't you the gentleman with the bad collar yesterday, day before?
Yeah.
They fixed that because I see a bandage on your one arm.
No.
Still hurts? It looks like it hurts you. Okay.
Just to bring to the court's attention, Mr. Williams has a pending burglary of a conveyance.
Right. That's when I saw him the other day when he had the bad collarbone.
I might
You
not
said it
have
was
been
messed
for
up.
that.
All right, sir. I'm hoping they'll give you the care you need. You're charging another count of burglary of an unoccupied conveyance, which is a car, while unarmed. I find probable cause. Your bond on that case is $1,000. All right? Good luck to you, sir. Hope you feel better. All right. Now back to Mr. DeBee.
Come on up, sir.
Okay, Mr. Reedy, did you have time to read it yet or not? I know I.
No, I did. I read it, Judge. I believe that Mr. DeBee should have a bond set for him. I think the evidence against him in this case, he's certainly not accused of being the person who committed the crime of murder. The evidence to me seems to be rather circumstantial, dealing with a lot of phone records and cell phone records. So I don't think that there is an establishment of proof evident presumption great here that would enable the court to hold Mr. Debe without bond.
State?
Yes, Your Honor, these are bondable offenses. I don't necessarily agree with the argument, the evidence. There are also phone call evidence where certain admissions were made, Your Honor. You guys, please. I do consider, Your Honor, first I consider Mr. Debe to be a danger to the community, being charged as an accessory on 3 counts of, or 1 count of first-degree murder, 2 counts of attempted. Additionally, I believe I have a concern about his future appearance in court. Your Honor, I can advise you he has an outstanding warrant. Just trying to find where it's out of. He has an outstanding warrant from an out-of-state, Your Honor, involving identity theft, credit card fraud. If I could just have one moment, Your Honor.
Sure.
My system went down. I just have to bring it back up. Does he have a hold out of Leon County still?
Yeah, he was already here.
So, Your Honor, I'm showing holds out of all those counties.
It's not much, it's just a copy of the warrant.
Pending cases. It appears, at least on some of them, there were
Mr. Rowe?
Mr.
Rowe.
Good morning, Judge. How are you?
You're disturbing the court. Could you please sit down? Okay, go ahead, sir. I'm sorry.
Okay, bring it up right now, Judge.
So he's got how many court dates he's missed?
He's got at least a warrant from another state, and I'm being advised by a confinement status that there's multiple counties in Florida that have holds on Mr. Debe also. Sorry, Judge. The warrant is out of, the out-of-state warrant, it is out of Illinois from April 18th of this year for showing fraud, illegal use of credit cards. He's got, let's see. He's got a pending, I'm showing a pending possession of cocaine out of Orange County from last year. Resisting without violence out of date 2015, I'm showing is open. He's had also causing concern about his future appearance. 2014, Your Honor, he was convicted of aggravated fleeing and eluding from law enforcement at a high rate of speed, resisting without violence. Another resisting without violence in 2013. 2011 grand theft auto, he violated his probation in that matter.
Are you saying he's a danger to the community and the only way to protect the community is to set a no bond hold?
I think at this point, Your Honor, that not only is he a danger to the community, but I think the only way to ensure his future appearance in court would be to hold a no bond.
Mr. Reedy?
Judge, holding Mr. Debe no bond is the most severe sanction this court can impose. I know he has some out-of-state holds that he's probably going to have to resolve and some out-of-county holds as well, so he may not be going anywhere anyway. But I don't think it's been established that holding him without a bond is appropriate in this case or necessary for the protection of the community in this case. I'd ask the court to set a bond. I don't know if Mr. Romero has any further information regarding Mr. Debe.
My understanding, Judge, is that the Illinois that Mr. Lender referenced was a not in custody case. It wasn't due to missing a court date. I know the case in Leon County he's currently sentenced on, so he is currently sentenced on that case, and he was transferred from Leon County to Broward County. He's been in custody since April 2nd, 2017. Judge, that's in reference to the 2 matters Mr. Lender brought up. I'd be asking you at this time, as Mr. Lender said, this isn't a punishable by life offense. He is entitled to a bond. I'd ask you at this time to set an appropriate judge for Mr. Debe. I think, Your Honor, maybe considering at this time holding him no bond. At this time, the defense would be objecting to that.
Wait, I haven't said anything yet. Are you reading my mind?
No, then I would actually set a reasonable bond.
Okay.
On Mr. Debe's behalf.
All right. Based on what I've heard, I find the defendant to not be someone who shows up for court He's got too many other cases out there where he has not showed up for court. I also think based on everything I read on this long transcript and everything that's been put together, the thing that I find a danger to the community is a statement that he said to somebody, a Miss Taylor, "Bitch, you think I won't kill you like I did that 8-year-old." I find that to be very disturbing. I also find the fact that he's missed court so many times and the nature of these charges and how long it took to actually find out that he was involved, and he's denied all that. So respectfully, I think I'm going to no bond him on all 3 counts. I think he's a danger to the community. The only way I can make sure he shows up for court and does not pose any other danger to the community is to hold him no bond on counts 1, 2, and 3.
Okay, now, Judge, if I can respectfully lay a record.
Sure.
As Your Honor is holding Mr. TV no bond, I believe at this time, pursuant to 3.122, there is a certain procedure that needs to be adhered to. Mr. TV would be entitled to a hearing. At that time, the defense would be allowed to present witnesses, their own mitigating circumstances or facts in order to articulate to his assigned judge not to hold them no bond. I don't believe that this hearing should be taking place in magistrate court. I believe what should be taking place in magistrate court is if the state asks you to hold them no bond,
They did.
Oh, I don't know if they did or not.
Mr. Linder did ask me to hold him no bond.
Oh.
And then he stated all his reasons.
Well, then he has to actually present a motion. It's a formal written motion, and basically that defense would be allowed time to go ahead and basically respond to that motion. If he doesn't have that motion written at this time, then Your Honor, just based on finding a probable cause, you could give him 3 days to file that motion, and you could hold him no bond for those 3 days, but he would still have to file that motion, Judge. And I don't think he's done that.
And it's not just a motion, Judge. There has to be an affidavit from the state indicating that they've had contact with witnesses involved in this case so that they can present that to the court and say, we have contact, we've spoken with people, this is why we feel that a no bond hold is appropriate.
Your Honor, just for clarification, what I stated was I don't believe that there are any release conditions that could ensure the safety of the community's future appearance in court. My understanding is it's still the court sua sponte ordering him to be held no bond.
So it looks like it's back on you then, Judge.
Of course. Isn't it always?
Yes.
I'm just noting for the record, I never prepared any kind of motion.
Okay. We'll let the division judge handle that. Okay? Good luck. You can bring that up in front of the division judge. Okay. Is there anything else? Everybody here? All right. Is 1:30 Thursdays busier than all the other days also?
Be here today at 9 o'clock. He got arrested the night last
For what?
night.
For what?
Missing court. He had a warrant.
If it was just the capias, it might not have come through, depending. I'm checking right now to see.
They'll look it up for you, miss. I'm sorry. I didn't see. I'm not going to ask everybody who they're here for because they normally.
All right, thank you. So I'll wait.
Yeah,
Yeah,
he
no,
was,
fine.
ma'am, he's on the